So for our third and final lecture today, it's my honor to introduce Professor Mark Lemley. And in just a moment, Professor Lemley will share with us his recent research related to substantive decisions in patent cases. But first, let me say a few words about Professor Lemley. Mark Lemley is the William H. Newcomb Professor of Law at Stanford Law School and Director of the Stanford Program in Law, Science, and Technology. Professor Lemley is a prolific intellectual property scholar, and his work has been incredibly impactful. He's the author of several books and well over 100 law review articles, and his work has been cited nearly hundreds of times by the courts, including the United States Supreme Court. And in 2014, he was inducted by Intellectual Asset Management into the Intellectual Property Hall of Fame. More personally to me, many years ago, while I was working as an associate at Foley & Lardner on a due diligence project, I ran across one of Professor Lemley's articles on divided infringement. And not only was the article tremendously helpful to me and made me look like a genius to the partner I was working with, but it also influenced me to write my own articles on the subject, which is one of the reasons that I'm standing before you here today at the law school. So today, Professor Lemley's presentation will again provide us with a unique view of patent litigation. And please join me in welcoming Professor Lemley.
All right, well, nothing says late on a Friday afternoon like data, right? We've heard I think frankly, across almost everything today, a pretty rosy view of the patent system, right? A system that has occasional problems, but they're really just occasional problems. Some patents are invalid, maybe. Some people are abusing the system, maybe. But really the problem is we don't have enough patents coming out as quickly as they can, and if we could only hold on to the patent system for 15 more years, I heard in a video, we'll have no pollution and no hunger. So that's exciting. What I want to do is to talk about the results of a major empirical study, actually 3 interconnected studies that John Allison at the University of Texas, Dave Schwartz at Northwestern, and I have put together, and that focus on patent litigation and litigation outcomes. And the upshot of all of this is it's complicated. It's a lot more complicated than I think we've been talking about in some respects so far today, because it's complicated on a variety of dimensions. What happens in patent court is a function of what industry you're in, of what technology you've got. It's a function of whether you're a non-practicing entity or patent troll, and if so, what kind of non-practicing entity. And it's a function of various other things, including what court you end up in. So we're going to take a look at a pretty comprehensive set of data for patent litigation. A little bit of background. John Allison and I published a study that's relatively well known in 1998 that studied how often patents were held valid when they made it to court. That study is now old. So am I guess. It's based on data that's over 20 years old, so our first thought was, well, let's update it, right? Let's see what's changed in 20 years. We also decided to expand it. So we expand it to include infringement and unenforceability as well as validity decisions. We include all district court and appellate decisions. One of the things you couldn't do back in the early 1990s was get access to all of the court decisions. You could get the reported decisions, which were mostly appellate and some important district court cases. Now, with the help of Lex Machina, we've got everything. And what we do is we collect data. We collect every patent lawsuit filed in 2008 and 2009. And the idea here was we want years that are recent enough that we've got some relatively current data, but that are old enough that virtually all of the cases filed during this period have been resolved. And indeed, the number of cases still pending from this cohort is less than 1%. And we take all of the cases in which there is a decision on the merits. whether it's a decision on summary judgment, on trial, appeal, whether or not it grants or denies the ruling. And then we spent a really annoying summer reading every one of these outcomes and trying to figure out exactly what the court did, and in John's case, reading all of the patents and trying to categorize them by industry and technology. The result is 945 merits decisions on individual patents. For each of these 945 merits decisions, we coded a host of different things. We coded all the possible grounds that a court might rule on, the procedural posture of the ruling, the technology of the patent, the industry in which the patent is deployed. And we also coded in the most recent version of the study, now making its appearance in public for the first time here today, entity status. And we did that in two ways. First is the practicing entity versus non-practicing entity, just a break in, are you actually putting products in the market or not? And then we broke down non-practicing entity because of the debate over who might be a patent troll into various different categories, splitting it into patent assertion entities, companies that are in the business of buying up and asserting patents from others, individuals, universities, and what we call failed startups, which are companies that are not buying other people's patents to assert them, but are asserting patents that they developed in-house, but that they never actually managed to practice. We also collect for each of the patents a host of independent variables. Where does the patent owner live? Where's the inventor live? Are they US or foreign? All of the characteristics from the face of the patent, the number of inventors, how long did the litigation occur, how old was the patent when it was asserted, how many people did you sue, what court are you in, and so forth. And we've end up in the regression analyses, including all of these variables to try to figure out what's driving litigation results. So let me start with just a few descriptive statistics of the world. So these are the technology areas that we categorize. Almost all of our patents show up in one of these 6 technology areas. You can see patent litigation, about a little over a quarter are mechanical patents. The largest single percentage are software patents, more than a third of all patents cases leading to a decision in our data set in this, from 2008 and 2009 are software patents. Chemistry, some of that, much of that is pharmaceuticals, although not all of it, as we'll see, represents about a sixth, and other smaller units. But information technology as a whole turns out to be just shy of half of all of the patent decisions, and a smaller chunk in the biomedical industries, and the rest spread among other technologies. That's the technology of the patent itself. We also coded the industry in which the patent's practiced. Now sometimes those are the same thing. Most biotechnology technologies are used in the biotechnology industry, but sometimes they're not the same thing. You could have a software patent that's in telecommunications, you could have a software patent that's in computers, but you could also have a software patent that's in automobiles, or energy, or a variety of other areas. So we wanted to actually distinguish between functional industry categories. And here we see some more interesting breakdowns. The pharmaceutical industry represents just over 10% of all the patent decisions. Computer industry is a somewhat smaller percentage than one might expect, 14%, but we've also broken out separately communications, which is another 13%, and other IT areas like semiconductors. We also measured NPE status. The 28% of the patent decisions in our data set were NPEs. Now that's an interesting statistic, I think, because it is less by all accounts than the number of cases currently being filed by NPEs. That's true, I think, for a couple of reasons. First off, this was suits filed before the AIA. So if a patent assertion entity or a patent troll decided to sue 40 defendants, that shows up as one observation in our data set pre-2011. It would show up as 40 different lawsuits today. The other reason it's different than what we see in the lawsuits is that many of the NPE cases are more likely than operating company cases to settle. Right? These are, remember, only the cases that go to some kind of decision. So if you sue 100 people and you settle with all of them, you don't show up in our data set here. Right? These are only the ones that go to at least some even interim decision on summary judgment. Break that down by type of NPE, what we see is that most of these NPE suits are either the patent assertion entity, the people buying and asserting patents, or they're individuals. We've got a few universities, but not very many. We've got a few more of the sort of failed startup companies asserting their own patents. And if you would prefer to see it in picture form, there it is. All right. We're going to now talk about outcome data, and as we move to outcome data, I want to just sort of raise the selection effects problem, right? What I'm telling you is what happens when the set of cases that go to at least some court decision. Not necessarily a final decision, could be an interim decision on summary judgment. That's a small universe of cases, right? Most cases settle, and most of the ones that settle without there having been a court judgment before they settle. So we can't tell you what the characteristics of the patents that never make it to court are. Right? We can't tell you whether those would have won or lost. All we can tell you is of the cases that actually do make it to court, what do the outcomes look like? One sort of interesting little test to show that those things are not exactly the same comes from our district data. So over here on the left, you'll see the percentage of decisions by district in our database. Eastern District of Texas leads with 13.5%, the District of Delaware just behind with 12.9%. On the right column are the percentage of all lawsuit filings, and as you can see, the numbers are rather different. What that means is that there's clearly some kind of selection effect going on here. It's an interesting one, I think, because what it tells us is that we're actually seeing overrepresentation in the Eastern District of Texas in cases that are going to some sort of judgment. They're, if anything, less likely to settle in the Eastern District of Texas than they are in other districts, so that more of them are showing up in our data set. So there's some reason to think that patent cases that settle without a judgment are different in some systematic ways. We can't tell you, of course, in what systematic ways. One thing we can tell you, probably not a surprise to anyone, is that patent trolls flock to the Eastern District of Texas. So we said 28% of NPEs overall in our study, 28% of overall plaintiffs in our study are NPEs. It's a substantial majority, 71 out of 127 in the Eastern District of Texas. Another way to think about that is operating companies file only 8.2% of their suits in the Eastern District of Texas. NPEs file 26.9% of their suits in the Eastern District of Texas. So Judge Gilstrap told us this morning he wasn't sure that he actually could tell you there were patent trolls in his district, but I can with great confidence tell you, depending on your definition of patent trolls, there are patent trolls in his district. Delaware, interestingly, has the opposite effect. Here we see an overrepresentation of operating company cases, 15% compared to 8% of the troll cases. Northern California has more operating than troll cases, although the effect's not significant. The Central District of California, interestingly, has almost twice as many troll cases in percentage terms as it does operating company cases. All right. What happens when these cases go to judgment? Let's start with summary judgment and summary judgment of invalidity. And here the interesting fact, I think, is with the exception of patentable subject matter, no one argument for invalidity does particularly well in court. Right? People file lots of summary judgments for 102, for 103, for 112, and for indefiniteness, and most of the time those arguments lose. Patentable subject matter is an interesting outlier here, not only because a majority of the motions won, but because we coded our cases before Alice was decided. Right, which means that a majority of the patentable subject matter challenges won on summary judgment even before Alice. I suspect that both the actual numbers are going to be higher and the percentages are substantially higher in the last year since Alice. This also, by the way, the indefiniteness numbers are before the Supreme Court's BioSig decision. in 2014. So I suspect, again, those numbers are going to change somewhat. The interesting thing about this is indefiniteness is the single most argued form of invalidity, even before biosig. And I think the reason for that is that it is argued primarily in the context of claim construction. So that rather than waiting until after a claim construction decision to file your summary judgment motion, a number of judges say, if you think this patent claim is indefinite, you got to tell me now as I'm trying to construe the claims, so we see an earlier opportunity in more cases to file that indefiniteness motion. So, summary judgments overall of invalidity, patentee tends to win most of them. There are a lot of them filed, so remember 945 cases, nearly half of the cases had a summary judgment of invalidity filed and decided. Patentee won a majority, but still a significant chunk of cases are invalidated on summary judgment. Patentees are much less likely to file their own summary judgments of validity, and when they do so, they're also less likely to win. Right? Summary judgment is, not surprisingly, skewed into a tool that defendants use more than that plaintiffs use. That's also true of infringement. A few summary judgments of infringement, and even fewer, a very small percentage, that the patentee wins. Lots of summary judgment of non-infringement are filed. More than half of the cases have a summary judgment of non-infringement filed, and more than half of the ones filed win. So the single greatest chance of losing your patent case as a patent owner is summary judgment of non-infringement. Right? Those are the ones that tend to knock out more cases than any other. We also see summary judgments of no inequitable conduct. Those are split about 50-50. We see no, that is 0, summary judgment motions for inequitable conduct. That just doesn't happen. Right? If you're arguing inequitable conduct, which is a major uphill road after Theracense, your hope is to get to trial. You're never going to win it on summary judgment. This was particularly interesting to us, trial outcomes. If you make it past summary judgment, we had just over 200 jury trials in our universe of cases. Patentees won 59% of those jury trials. We had a smaller number of bench trials, about 80 bench trials. Patentees actually had a higher win rate in bench trials than they did in jury trials. That's contrary to what prior evidence has suggested. Our evidence, when we back out of this, who is it? One way to think a question is, who in the modern world takes their patent case to a bench trial, right? And the answer is pharmaceutical companies in ANDA cases. And that, as we're going to see, I think is going to be an explanation for this higher number, because the pharmaceutical companies do particularly well. So jury trials, no guarantee of a patentee win. You're doing pretty well, right? But you got more than half. But by no stretch of the imagination are you guaranteed in the door once you get before a jury. Combine summary judgment and trial data, overall invalidity results, some of the numbers start to go up a little bit. So, about nearly a third of the patents that adjudicate a 102 issue find the patent invalid on that ground. More than a quarter of the patents that adjudicate an obviousness issue find the patent invalid on that ground. The other invalidity claims are still relatively small. But when you add them all together, because the accused infringer only needs to win one of these arguments to kill the patent, 42% of the patents adjudicated are invalidated in the courts. And that's interesting for a couple of reasons. One is it's pretty broadly consistent with what the data looked like 20 years ago. The number 20 years ago was 46% in the study that John and I did. Now there were some incomparability issues in terms of the data set, but the fact that sort of just under half of the patents that adjudicate validity find that to be invalid has remained largely unchanged over the last 20 years. You not only need to win the patent validity issue, of course, though, as a patentee, you've also got to win infringement. And as we said, there are lots of summary judgments of non-infringement. There are also some trial decisions of non-infringement. The result is that the patentee win rate overall in cases that go to a decision is 26%. Patentees win 1 in 4 of their cases. This, too, turns out to be remarkably consistent. It is exactly the same percentage that Paul Janicki at the University of Houston found over a decade ago in studying results. So while we've seen an enormous amount of movement and swing in the legal doctrines in the patent system, right, things seem to equilibrate to about the same place that they did 10 and maybe even 20 years ago, which is patentees win about a quarter of their cases overall. All right. How does that break down by technology? This is just a reminder of the different technologies, right? Software being the largest one, but mechanical and chemical also substantial numbers. One thing to note about technologies is that we see very substantial differences in whether or not you are an NPE by area of technology. Some of that is not too surprising. Chemical patents tend to be practicing entities, not NPEs. Mechanical patents tend to be practicing entities, not NPEs. Software patents, by contrast, overwhelmingly NPE lawsuits. That is not merely a function of business methods, though it's true in business methods, it's also true in the non-business method software world. Most of the NPE lawsuits are software lawsuits, and certainly most of the software lawsuits are NPE lawsuits. Win rates by technology, we found this quite fascinating. So chemistry, head and shoulders above everybody else. Overall win rate, we said, was 26%. Chemistry doubles that, 52% win rate. That doesn't sound so great until you compare it to everybody else, right? Electrical does okay at 30%. Mechanical does okay. They're about the norm, 27%. Optics down to 16%. Software, 13.5% win rate. Right? Just over 1 in 8 software patents ultimately wins when it goes to judgment. And so far, that story is, I think, consistent with the narrative that you hear expressed in the patent policy debates, right? There's a gulf between the biopharma world and the software world. Biopharma depends heavily on patents. It's important to them their patents be strong. Software, there are many more questions about the validity of the patents, about whether those patents are serving useful purposes and so forth. That seems to be borne out. Except, look at the one we haven't talked about yet. Biotechnology patents have a 5.4% win rate. Now that's remarkable to us. I think it's remarkable for various reasons, but the most remarkable thing I think is that if you're to sort of talk about that policy divide, you'd lump in biotech with pharma in the folks that really need strong patents, that care a great deal about the validity of their patents and depend on them in an industry, but they're not doing well in the ultimate outcome. Melissa. Yeah, so this is technology, not industry, right? So pharma cases are almost all going to show up in here because they're almost all chemistry. Medical devices depend a little bit. Medical devices are probably mostly in mechanical, but some of them may show up elsewhere. The biotech tech category we define in the paper, it's fairly narrow, so it tends not to have the medical device cases in it. But we'll get to industry in a minute, which will also help to break that out. So interestingly, when you break down these win rates, so this is the invalidity rate. Why is it that biotech's losing so much? Well, one reason is 80% of the biotech validity decisions find the patent invalid. We're compared again, remember, to 42.6% overall. Mechanical, again, at about the norm. Chemical, do patents, including pharma, doing very well, 25.6% invalidity rate. So they're doing quite well. Interesting to us was software, right? Despite all of the complaints about bad software patents, the software patent invalidity rate is pretty much about the norm. It's 45.3%. That's not small, right? But it's not substantially different than the average across all industries, suggesting that it's not the problem with software patents. The reason software patents are losing is not that they're all being invalidated. The reason instead has to do more with infringement. All right, so the total infringement win rate for patentees is 36%. Chemistry, again, Leading the pack, 68.4%. That's not so surprising because it includes a bunch of the pharmaceutical ANDA cases, and you ought to win your ANDA case on infringement, right? Because the defendant copied from you by definition. Not all of these are ANDA cases and so forth. Biotech also not doing well on the infringement side. Not only were they invalid, they're also not infringed very much. Software, the real problem in software patents seems to be infringement. Less than 20% of the cases lead to a finding of infringement. Sorry.
The 945 cases, how many are filed?
So the answer is a relatively small number. It's about 35. So we were quite shocked by the biotech numbers, and so we went back and tried to blow this up and make it an artifact of the small numbers. And we went back and studied each one of them separately and tried to say, well, maybe it's just one kind of chunk of cases or cluster of decisions or one kind of party, and it doesn't seem to be. But the answer is it's relatively small. And so I don't know whether that is a function of lots of biotech cases settle. That's a possible explanation. It may be that there are just fewer biotech cases being litigated out there relative to software. I think that's probably true, but relative to other industries, I don't know. It's an interesting question. All right. Industry tells a fairly similar story. Here we affirmatively break out, Melissa, the pharmaceutical folks specifically. NPE status, again, has some fairly different characteristics. A lot more NPEs in the computer and electronics and the communications industry. Fewer NPEs, like no NPEs in the pharmaceutical industry. Biotech here was interesting. There are actually almost as many, or there are as many NPEs in the biotech industry as there are in practicing entities in percentage terms. And that was a bit of a surprise to us. Definitive win rates by industry, again, biotech not doing so well, 8.3% here. The computer industry also pretty low at 17%. Our overall pharmaceuticals doing the best overall at over 50%. So some interesting differences in the individual breakdowns, but pretty consistent with what we did in the technology side. And we've got the infringement and invalidity data as well. I will give, by the way, the SMU folks a copy of these slides. Most of this is in 2 papers that we've cited to you, but you are welcome to have the slides to download, and the 3rd paper is coming really soon. The 3rd paper deals with the NPE outcomes. So we said the overall win rate is 26% for patent owners. Operating companies actually win just over 30% of their cases. NPEs of all stripes win 14% of their cases. So NPEs are not actually doing all that well. When you break it down by who the NPEs are, what you find is some variation. Universities do just as well as operating companies. They're winning about 30% of their cases. The failed startups do all right. They're winning a little less than average, right? 21, 22% of their cases. Individuals winning 14% of their cases. And the dreaded patent assertion entity wins less than 10% of the time. Now, we also wanted to try to interact that with industry characteristics. So one of the things we did, which I haven't presented here, is to pull out the ANDA cases and separate them from other pharmaceutical cases. But the other thing we did is we decided to look at, well, all right, what's going on with these NPE cases? Is it just software? They're all asserting software patents. We've seen they disproportionately assert software patents, and software patents do badly. Or maybe does it work the other way? Software patents do badly because they're being asserted by NPEs, and NPEs do badly. One we found was quite interesting, which is NPE plaintiffs in software cases do just as well as operating companies. In fact, they do slightly better than operating companies. Software patents are losing most of the time, not because NPEs are filing bad software patents and losing, but because software patents are losing regardless of who files them. Even operating companies asserting software patents are winning only 1 time in 8. And when you break that out, you again see some variation. Universities asserting software patents are actually doing the best, and failed startups are doing quite all right. Individuals and PAEs not doing so well, winning again only about 1 in 10 cases. But nobody's doing all that well, right? I mean, the only universities with a very small n, right? There are only a few cases here, are winning a substantial number of software patent suits. Non-software patent suits by NPE status. If it's not a software case and you're an operating company, well, your numbers went up a bit. Now you win about 36% of the cases, right? Because you're not asserting software and you also aren't an NPE. Universities leave aside, there were only 2 non-software university decisions in the data set, and they lost both of them, but I'm not sure we can learn anything from that. The interesting number here to me is the patent assertion entity. Patent assertion entities win 5% of their non-software cases. They actually do better in software cases than in non-software cases, even though other people tend to do worse. All right, well, what's going on here? Patent litigation seems to be a kind of pretty big roll of the dice, right? You lose most of the time. If you're an NPE, and particularly a patent assertion entity, you really lose most of the time. If you're a software patent plaintiff, you really lose most of the time. So what are people doing? Well, one thing we can learn from what they're doing is the difference between interim and final patentee wins. So one of the things we decided to figure out is not just did a patentee win their case, but did a patentee survive summary judgment and then settle their case? Right, so we added in the universe of cases in which summary judgment for a defendant was denied, but we never ended up going to a final judgment. And here the patent owner interim wins are quite substantial in the software and the mechanical areas, and indeed even in biotech. Right? So a possible explanation for what's going on here, right, is that the business in many of these cases is not about winning your case, whether at summary judgment or at trial. If I can survive an early knockout, if I can survive summary judgment, then I'm going to get paid. I'm going to get paid outside the legal system, right? I'm going to get paid in settlement. And so the business may well be profitable in the software and indeed in the biotech world if I can get to that stage, even though ultimately my chances of winning if I'm taken to court are pretty small. So what do we learn from this? I think there are really significant industry differences in the patent system that we need to take account in setting patent policy. This evidence is part of that story because of the selection biases I talked to you about earlier. I can't tell you, right, all pharmaceutical patents are good and all software patents are bad. All I can tell you is what happens when we go to judgment. But the story that we need stronger protection in the pharmaceutical industry than we do in the software industry is one that seems to be borne out by the patent outcome data. The outlier to that story, the one that we have to struggle with, I think, as a policy matter, is biotech, where all of the policy arguments suggest we need strong patent protection, but we don't seem to be getting it. It's also more complicated when it comes to practicing entity status. Non-practicing entities unambiguously do worse than practicing entities, but non-practicing entities aren't monolithic. Patent assertion entities fare worse than any other category, while universities and failed startups do substantially better. Software patents do poorly regardless of who asserts them. Right, and it's not, indeed, NPEs don't do any worse. NPEs outside of software do particularly poorly, especially PAEs, which win only 5% of their cases. So talking about NPEs, I think, ends up concealing a bunch of complexity. Right? It makes a big difference whether we're talking about a patent assertion entity or whether we're talking about a university or a failed startup. It makes a big difference whether we're talking about an NPE or a patent assertion entity that's asserting a patent in software or whether they're asserting it somewhere else. So the result, I think, is a sort of more complex and nuanced picture of patent litigation. It's not simple. It's not black and white. It's not patents good. It's not patents bad. It's, well, it depends. And with that resounding conclusion, I think I'll stop. Time for a few questions?
Yeah, absolutely.
All right, questions?
Have you contemplated any ways to determine the occurrences that happen before the settlements, things like that, to evaluate, are we really seeing a lot of frivolous cases that just never make it to a
Right.
judgment because the parties
Yep.
don't want it to get there?
Right.
So have you thought of how to evaluate that?
Yeah, so the problem is, of course, that all the settlement data is confidential, with few and very atypical exceptions, right? So it's not confidential if the settlement is sufficiently large that it's material to the bottom line of a publicly traded company, but of course that's an asymmetric case. It's not confidential if the defendant demands not only that I pay nothing, but that I get to tell the world that I pay nothing. That's an asymmetric case in the other direction. Right? But in the vast run of cases, we don't know whether a settlement was, okay, your case was lousy and so walk away and I won't seek fees against you, or I'll pay you a big chunk of money to drop this, or something in between. What we can do, we haven't done here in this study, but you can see from other data, one thing we do know is a surprising percentage of patent cases settle very early in the process. Right, so what you might expect, which is we're going to get some judicial determination and clarity. Judge Gilstrap talked this morning about claim construction and then mediation. We don't actually see that the parties go until you tell us what our claims mean and then we settle. Sometimes that happens, but most of the settlements that happen early in the process. That's consistent with a kind of shakedown nuisance value settlement story. But it's not proof of a nuisance value settlement story, right? It's what you'd expect to happen if the answer was, I sue you and I say, pay me $1 million now, or you'll pay your lawyers $5 million down the line. But it could also be consistent with settlement or lawsuit as a continuation of a license negotiation, right? Where I just tried to ratchet up the pressure. And it just turns out to be really hard to distinguish those without access to what happened in that settlement.
Mark, I was wondering if there's any correlation between the expense of the case, the intensity of the case. So you could have on the extreme a default judgment
Right.
because there are 18 Taiwanese manufacturers
Yep.
that never answered versus a 1,500 docket entry case.
Yep. It's a good question. So we leave default judgments out of this, by the way. So these are all cases that went to a contested judgment. We left out default judgments and we left out consent decrees that didn't follow a merits ruling, right? Because we figured those were essentially either settlements or abandonment of the case. But yeah, I think, so one thing you can do, Jay Kason at the University of Illinois has tried to do some study on kind of litigation intensiveness, just counting docket entries as a measure of litigation cost. You know, it's an imperfect measure, of course, but it's certainly correlated.
Do you think the higher the docket entries, the more likely the success? The lower the docket?
Maybe, yeah. Well, it's interesting. I mean, yeah, one of the difficulties is there's a whole economic literature on how do we figure out which cases actually go to judgment when we know most of them settle, right? And so Priest and Klein 30 years ago kind of said, well, we just think it's going to be 50-50, right? The ones that'll go to trial are the ones where it's so close that each side thinks they're going to win, and so they'll just try it out. That turns out not to be true, and there may be various kind of strategic reasons why it might not be true, right? If I'm suing 20 people with a patent, I've got different incentives in deciding to go to trial with you. If you're a company who's got 30 troll suits against you and you want to establish a reputation for toughness, you know, people might behave in strategic ways. So I think we clearly could correlate the success to the intensity of the litigation and see what we find. I think that'd be interesting. Dave.
Mark, point of clarification on this is your methodology, right? So does Michelle remind us that patent quality doesn't make as much sense as patent validity, and patent validity is on a claim-by-claim basis. So is this invalidity win rate on a...
Yep.
So would that be all the
So-
claims were invalidated?
So the answer is what we did is our unit of measure is by default the patent. Contrary to what Judge Michel said this morning, about 85% of the time, patent claims litigated in a case always stand or fall together. Now, part of that is a selection. Which claims did I choose, right? I may have chosen only the claims that I think have an infringement read. But so most of the time, we didn't have to go below the patent level. We did, in cases where the different claims were treated in different ways, we ended up coding them separately. And then we ran two specifications. One in which we treated each of those as a separate independent ruling. But we're not sure they're really separate independent rulings. So we also ran them with a specification in which we sort of treated any claim surviving in the patent as a patentee win. There weren't substantial significant differences between the two specifications.
Is there a reason that you stopped the case in 2009?
So the answer is we coded this, we started this project in 2013. We were afraid that if we included 2010 cases, a sufficiently large number of them would still be pending, and those might in some sense be the most interesting ones. They might be the ones Bart's talking about as having been really hard fought and therefore lasting longer. We wanted to try to get out of that universe. One of my co-authors says, hey, well, gosh, you know, now it's 2015, we ought to add a couple more years of data, and he's not the guy who had to hand code all these things. So the answer is no. I actually left some of this out. There are some, it was consistent across most districts. There is, when we ran the regression analyses, the Eastern District of Texas is statistically significantly more likely to rule for patent owners. And the Central District of California was less likely to rule for patent owners. And those were the only two that sort of survived all of the various different variables we threw at it. But the ED text numbers, I think, were pretty substantial. And, yeah, of course, factor that into all of the other things we talk about. EDTex has more troll cases. It has more software cases. Those are each less likely to win. So the overall win rate in the EDTex isn't necessarily greater than it is elsewhere. It's greater than one would expect, given that the cases that are being asserted there tend to lose more than other types of cases. Anybody else? All right, hopefully I have managed to speak until they got the food set up outside. Thank you all very much.
All right, thank you very much, Mark. So I have the honor of giving the closing remarks, and I promise that I'll be brief, but I do want to say a few things. And first, on behalf of Professor Taylor and myself, I would like to express gratitude for all of those that made this event possible. The planning for this conference began in early 2015, and Professor Taylor and I sat down and we wanted to bring together some of the brightest minds in the country to talk about intellectual property. But we also wanted to set an agenda with respect to innovation and intellectual property for the next few years for the center. Accordingly, I want to really thank the speakers and the panelists for today for sharing their research, their experiences, their ideas. I think all of us have been enriched by what you've shared with us today. Second, as anyone who's ever planned a conference knows, it cannot be done alone. And it cannot be done well without the help and enthusiasm of a great team of people. And this morning, the dean mentioned those people, but I feel that I should at least mention their names again because they were so instrumental in helping us. And so, again, Professor Taylor and I would like to extend thanks to Rebecca Bell, Lynn Dempsey, and Christy Offenberger. In addition, we'd like to extend special thanks to the Ty Center Fellows, who are two law students here, Alex Bridge, and Kristen Zanow. Could you guys stand up, Kristen and Alex? Thank you, guys. They did a tremendous job helping us, and I've learned probably more than I want to know about Instagram and other social media sites because of them, but thank you very much. And then finally, I would like to thank Jennifer Collins, the wonderful dean of our law school. Her leadership and guidance have been crucial to making this conference a success, and I'm certain that under her leadership, there are more great things to come, not only from the center, but from the law school. So please join me in thanking Dean Collins.